Everybody. Hello everybody and welcome. My name is Pacific Maniakiza. I am a prof in the French Common Law program. I am also a co-chair of the International Law Group, which sponsored this today's talk, alongside with my colleague Tony Van Duze and also Jalloh, who is going to join us shortly. First of all, let me recognize that this talk takes place on the ancestral and unceded territory of the Algonquin Nation, to whom we pay tribute. Today's talk is on a particularly thorny issue of international law, jus cogens, whose content is not necessarily clear. But at the same time, I think the issue of jus cogens norm is very, very important, at least for two reasons. First of all, premièrement, l'importance des normes de jus cogens réside dans leur raison d'être et le fait qu'elles reflètent et protègent les valeurs fondamentales de la communauté internationale dans son ensemble. Et de ce fait, sont revêtues de valeurs, mais aussi de valeurs de force, mais aussi de valeurs qui est supérieure aux autres normes ordinaires de droit international. Secondly, I think the importance of jus cogens norms derives from the fact that it is a cross-cutting issue, in the sense that the notion is everywhere in all areas of international law, and every international lawyer will face it no matter his area of specialization in international law. Despite the importance of jus cogens norms in international law, as I said again, its content is not clear, and it is not easy to determine and ascertain when a particular norm has reached that particular status. So in order to shed light on this rather nebulous concept of international law, we are privileged to have Professor Charles Jalloh, who generously accepted our invitation to share his insights on the issue, despite his numerous occupations. It is now my pleasure to introduce our guest speaker, Professor Jalloh. Professor Charles Jalloh is a professor of international law at Florida International University, and he's also a member of the United Nations International Law Commission. And the International Law Commission is very, very well known at our faculty, especially given that one colleague of ours, a prominent member of our international law group, Professor Donald McCrae, also served, I think, 2 terms on the International Law Commission. And we are privileged to have you here present. So Professor Jalloh is an active member of the ILC, and his contributions, his dedication, and his hard working have been recognized through his election to leadership positions at the ILC. First of all, as a chair of the drafting committee during the 70th session of the ILC, and also as a general rapporteur for the 71st session. Professor Jalloh is a prolific scholar. He has published extensively in international law, mainly in international criminal law, and I had a privilege to author two chapters for his recent co-edited books, one on the African Court of Justice and the Human and People's Rights in the Context, Development and the Challenges, which has been published by Cambridge in 2019, and another one, Africa and the International Criminal Court, which has been published by Oxford in 2017. He is also a founder and editor of 2 important law journals, the African Journal of Legal Studies and also the African Journal of International Criminal Justice. In fact, Professor Jalloh is what I can call in French oiseau rare, an oiseau rare or oiseau bird, one in a million, who combines excellence in research, in teaching, and also in practice of international law. Before joining the academia, Professor Jalloh has practiced law, international law, at both domestic and international levels, including the Canadian Department of Justice. He also served at the Special Court for Sierra Leone, the special he also served at the International Criminal Tribunal for Rwanda, and he has also advised many governments and international organizations, such as the African Union. For instance, he has appeared before the International Criminal Court in the famous immunity case concerning al-Bashir on behalf of the African Union Commission. And Professor Jalloh, let's say, as far as the ICC is concerned, he was the chair of the panel of experts on the election of the ICC prosecutor, which was established by the ICC Assembly States parties in 2019-2022. In fact, doing justice to the bio of Professor Charles would require another talk, but let us save it for later and give him a chance to address us. So please join me and welcome Professor Jalloh to give us a talk. Over to you, Brother Jalloh.
Thank you so much, Pacific. It's a pleasure to be here, and it's nice to see so many friends and colleagues, some of whom I haven't seen for many years. It's an absolute delight that you invited me, and I'm grateful to the International Law Group of the Faculty of Law of the University of Ottawa for inviting me to share some reflections on the work of the International Law Commission. And thank you very much, Pacific, for a rather generous and hardly really due introduction. It could have been much shorter from where I'm sitting, but thank you to you and of course, Anthony Van Dueza, who I just met in person. I've seen his name in the papers, and other colleagues of yours for arranging this talk and for making me part of the conversation today. I regret, of course, that I couldn't be there in person. I was just saying just before everyone joined that I really was looking for an excuse to come back to Ottawa after so many years, but regrettably, given the context of COVID plus what's happening in the city, I think it was better that we could do it this way, but I'm looking forward to another chance to come back. So here's my pitch to be invited back to Ottawa. Of course, as Pacific mentioned rightly, the concept of use Cogens is quite an interesting but always challenging one. And when he suggested the topic, I thought it would be a good thing to do for a couple of important reasons. So firstly, and he mentioned some of the practical elements and challenges concerning the concept, is always a fascinating one for international lawyers. This, of course, is an area where the work of the International Law Commission has been quite prominent as a historical matter. The concept of use Cogens itself, of course, is quite significant because it's the closest to what we would call supernorms from the point of view of international law. Supernorms, to the extent that they act as the only, at least formally accepted limitations on state sovereignty, meaning that there is some kind of hierarchy of norms in international law. So the views on the topic, of course, vary among states, but also among academic observers. The second thing that I thought was interesting about use Cogens, and perhaps made it interesting as a subject of a talk, is that the ILC did really play a prominent role historically, especially in the context of the work of the Commission on the law of treaties in the 1960s, essentially lifted use Cogens into the stratosphere of international law by putting it front and center in the project on the law of treaties. And there, in that project, the Commission had proposed about 3 draft articles, which eventually found their way in some modified form in the famous Vienna Convention on the Law of Treaties, so the VCLT. And so from that point of view, the ILC has a long history with the topic, but it didn't end there in the VCLT. In fact, the Commission, over the course of its projects on a range of other topics, including the question of state responsibility, the responsibility of international organizations, went back and dealt with, although tangentially, the element of peremptory norms of general international law jus cogens. So really, it's a topic that I think has a long ILC connection, and now, of course, it's come back to the Commission in some kind of fashion as a project standing on its own. Having said that, I asked Pacific to circulate last week a set of the draft conclusions that have been adopted by the Commission on first reading in 2019. And the thought there was to basically use this talk as an opportunity to share what the Commission has done in returning to the topic of jus cogens, a topic that is actually at the cusp of completing, because after all, the plan is, if all goes well, just this year, when the Commission would resume its 73rd session in Geneva in about 2 months, it will be starting with the topic of jus cogens, which will be a second reading. So it's a really, I think, good topic. It has a lot of interesting legal and theoretical dimensions, some of which we will not be able to get into today. But in organizing my talk, what I thought I would do is to present about 3 big questions that I will try to then address, while at the same time, of course, leaving some space for conversation afterwards to address both matters that I may have touched on, but also matters that I haven't touched on. So in terms of the 3 questions, the first I thought would be important to address is, why did the ILC take up this topic? And of course, Pacific mentioned Don. In fact, Don probably has more insight as to why it took it, because Don was in the Commission at the time, and they were the ones debating it in the context of a proposal by a member to present the topic in the working group on the long-term program of work. But firstly, why did the ILC take up this topic of jus cogens? That's the first, I think, big question. Secondly, what is the current status of the ILC's work on this topic? Where is the Commission on it, and what has the Commission done in terms of the substance? And thirdly, what are the likely next steps for the topic? Now, in thinking about these 3 questions, let me just make a couple of broad observations. And I think it's already clear from the audience that most of the colleagues in the room, although I understand that there are also some students, would know what the ILC is. And I was just going to start out by saying a couple of things about the Commission, at the risk of perhaps maybe even oversimplifying, by just sharing 3 quick background points about the Commission. The first point, of course, is that this is an independent expert body of the UN General Assembly, created in 1947. And the idea was really to give some legs to what is Article 13 of the Charter of the United Nations, which gave responsibility to the General Assembly to initiate studies and make recommendations to the UN member states with the view to, firstly, promoting international cooperation in the political field, and secondly, encouraging the progressive development of international law and its codification. I should mention that in the lead up to the adoption of the Charter, there had been different ideas about the role of international law, including the possibility, some proposals to have legislative authority for the UN itself. And there was another proposal that the GA be given the function of taking binding decisions for states. All of this did not fly, of course. I don't think they would probably even fly today. But the compromise was something along the lines of Article 13, which recognized a role for the General Assembly as the most representative organ of the UN itself to promote international cooperation. And in the same spirit, recognize also that international law has a role to play in promoting international cooperation. So there's a link between these 2 aspects of paragraph 1 of Article 13. Now, if you look at the ILC statute, it basically purports to give the function of the Commission in a kind of 2-frame approach. So one is that the Commission would have as its object the promotion of the progressive development of international law and its codification. So the progressive development prong and the codification prong. If you go further into the statute itself, as ILC members often do, you will find in Article 15 that the statute basically tries to specify what each of these two prongs would mean. And essentially, it was meant to be a definition for convenience. And in progressive development, it was for the Commission to address areas of international law that had not yet been regulated sufficiently by international law, or there isn't enough state practice. And then codification, on the other hand, which is the second prong, was to have the Commission do a more precise formulation and systematization of rules of international law in fields where there has already been extensive state practice, precedents, and doctrine. So really it's this notion that you have two distinct things going on, and this commission would be addressing those two prongs and assisting the General Assembly. Now, what is interesting is, in terms of the frame of the statute itself, it does contemplate different procedures for each of these elements of progressive development on the one hand and codification on the other. The reality, of course, is a little bit more complex. And I think if you look at the history of the drafting of the statute of the Commission, there were differences of view early on as to whether you can, in fact, draw that distinction. So what the Commission has done in practice is basically develop projects. And depending on the project, you would have more progressive development than codification, or codification and more codification and progressive development. So essentially, think of it in terms of a continuum. You are in a sliding scale depending on the topic. That's just the reality of it. Although there are states that insist up to today, vociferously, 73 years down the line, on making a clear distinction between codification and progressive development of international. And that's one of the fault lines, really, in my view, about the Commission. I think Dawn has been among the members who's really tried to grapple with this in terms of scholarship. So I will just end there on that note in terms of just the background as to what exactly the ILC was supposed to do. And then the second contextual point, very briefly, is to know, of course, that 34 members drawn from around the world, nominated by state, elected by states, working part-time. And the most recent election actually just happened in November of last year. And for the 2023 to 2027 quinquennium, members go to Geneva, of course, to do their work, and they work pro bono, so there's no formal remuneration. And in terms of Canada, I thought, of course, the Canadian connection, two of which actually are connected to the University of Ottawa. 3 Canadians have served on the commission. Of course, Marcel Cadeau, who is the first Canadian, a Canadian diplomat and professor of international law at the University of Ottawa. John Beasley, who was a diplomat, and of course, the very Don McRae, who's sitting right in the room right now. So it's very interesting, the connection that Ottawa U has, in Canada has, to the topic includes strongly a University of Ottawa presence. Of course, we know that Canada, along with Australia and New Zealand, like the Nordic countries, try to share a seat. So that perhaps explains the 3. And then finally, let me just end in terms of that introductory set of points about the Commission and background, that the Commission has been quite significant in terms of the development of international law, and is known very well for its contribution of draft articles in a whole range of areas of international law. So everything from the law of the sea, diplomatic and consular relations, even work in specialty areas, if you think about international criminal law, of course, the national environmental law, and a number of others. Now, what I would stress, though, is that in thinking of the Commission, it thinks of itself broadly, I think, as a general international law body. So it's really focusing on aspects of general international law and tries to stress that. And so from that point of view, it really has done a lot of work on sources of international law along the lines of those that are specified in Article 38(1) of the ICJ statute. So you think about treaties, customary law, and general principles of law. And starting with treaties, and that's the one that's most closely connected to the discussion today, the Commission has really made an important contribution through the work on the law of treaties in the 60s, but then all the subsequent spin-offs, so to speak, of projects relating to the law of treaties, including one that was just concluded this past year on provisional application of treaties, which is really just dealing with one provision of the Vienna Convention. So it's really been a mainstay in many ways for the Commission, the work on sources. Now, what is important about the law of treaties project in particular is not just that we got the basis for what became the Vienna Convention, the so-called Treaty on Treaties, but that we also in that treaty would find this fascinating idea of jus cogens, right? So it's really, really quite interesting because it set the base very well for the entry, if you will, or the elevation, if you will, of the concept of jus cogens. So from that point of departure, really coming back then to my 3 key questions, the first question was, if you would recall, why did the ILC take up jus cogens? And a related question would be, why is use cogence important? And in my view, the topic, of course, had come to the Commission because of that historic role it has played, in part because it really then, it does not mean that it introduced the concept. The concept is accepted to have been around in international law, but in Articles 50, 61, and 67 of the draft articles on the law of treaties, bringing in this notion of use cogence and trying to clarify, the Commission essentially played an instrumental role in bringing state acceptance and development of the norm of use cogence. And that, of course, raises the question, what exactly are use cogence? Well, although the definition that was provided was for the treaty context, it ended up being Article 53, and it said that a treaty would be void if at the time of its conclusion it conflicts with a peremptory norm of general international law use cogence. And it goes on to say in Article 53 that a use cogence norm is a norm accepted and recognized by the international community of states as a whole, as a norm from which no derogation is permitted, and which can be modified only by a subsequent norm of general international law bearing the same character. So this is really, really quite far-reaching provision in terms of what the Vienna Convention says. And of course, there's Article 64, which is the corollary of sorts in making clear that if you have a new peremptory norm that emerges, an existing treaty that is in conflict with that peremptory norm would then become void and terminates. So this is really as far as the Commission got in terms of its project on the law of treaties. And it was a bit of a controversy around the issue, although there was broad support for the inclusion of these draft articles in the ILC project. And eventually, obviously, we see that manifest in the Vienna Convention itself. But even at the time, and this is really important, the ILC left some key questions open in terms of the project, in terms of what use cogence mean, and very importantly, what are the consequences of a finding that there are norms of international law that effectively would be the super norms as I characterized them in the beginning. So for the longest time, the Commission basically took the view in terms of the law of treaties that it would leave some of the questions open and have them worked out in state practice and the jurisprudence of international courts and tribunals. So that meant in the next set of decades from the 1966 period, there hadn't been much of a conversation in terms of whether the Commission should take up use cogence, because everybody understood that the Commission had left some questions open to be worked out in state practice. But in 1993, the Cypriot member of the Commission, Mr. Andreas Jacovidis, observed that about a quarter of a century had passed since the VCLT had been adopted, and that there had been no authoritative standards that have emerged to determine the exact legal content of use cogence or the process by which international legal norms may rise to peremptory status. So he made a proposal to the Commission that it studied this issue. At the time, the Working Group on the Long-Term Program of Work was chaired by Professor Derek Bowett, who reported back to the Commission and had the view that there was the overall takeaway from the discussion was that there's no sufficient practice in the area and that the Commission should not go into studying use cogence because the issue will be premature. So it's rather quite curious that it's about just over a decade later, in 2014 to be precise, when the use cogence issue was raised again. This time it was successful. It was presented by a South African member of the Commission. He noted in his submission to the working group that the practice had developed at a rapid pace, and he pointed out that there had been a lot of jurisprudence in international courts and tribunals where there had been references to use cogence. The difficulty, of course, remained that the precise contours, the content, and importantly, the legal effects of saying something is use cogence remained in doubt. So in the end, at that stage, the Commission could agree. So the item was added to the long-term program of work of the Commission, forwarded in the 2014 report of the Commission to the General Assembly to invite comment from states on the question. And in the fall of that year, it's very, very interesting when you look at the debate of the ILC report, about 18 states, 18, so 1-8, offered comments on the topic. Most of them were positive about the topic. about 13 in total, although not just the 13 number is important because some of them were speaking on behalf of others as well. So if you add it all up, it works out to about 48 states in total supported the inclusion of the topic on the long-term program of work. There are a couple of states that were ambiguous in their response, and there are a couple of P5 members that had very serious doubts about the viability and the appropriateness of the commission taking the topic, pointing out that in fact they didn't agree with the assessment that there was sufficient practice in the area. Having said that, this was sufficient for the commission in terms of its working methods once a space opened up in the program of work to add the item to the program of work. And in ILC terms, this was done in 2015. The commission appointed the proponent of the topic as its usual practice, Professor Divesh Ladi of South Africa as the special rapporteur. And all the way to 2019, the commission had been now grappling with this topic of use Cogens. So this is really, in ILC terms, pretty fast, 7 to 8 years for a project, because ILC is famous for deliberating and sometimes for deliberating too much. I mean, obviously we have extremes like the state responsibility that took over four decades. That's an extreme for sure, but the commission doesn't complete things quickly. It's a deliberative body and it takes its task very, very seriously. Having said that, in this topic, the commission as of 2019 basically had gotten to the point where it was comfortable to send an item upon first reading to the General Assembly. So that's really, it brings me then to the second question, which is, what is the current status of the work of the commission on the topic, and what is the substance that had been adopted in 2019 and sent to the General Assembly in the 23 draft conclusions that the commission adopted with commentaries, and that the commission invited states to give their feedback on. I should note in parentheses, of course, that the element of the ILC being able to engage with states, whether it's in terms of suitability of a potential item, but also the annual feedback that it would get on draft articles, all the way to the final stage where it gives a longer period of time, over a year normally, to states to comment, is one of the elements that makes the ILC work very significant. It stands out. Obviously, we have a lot of international law expert groups. We think about the International Law Association and others out there that have done fantastic work. Ultimately, they're private bodies and they don't have that engagement and interchange with states. So this is quite significant for the commission. So getting an item to the 2019 first reading stage is quite significant for the commission, because then they give the member states of the UN a full view of the entirety of the project and the supporting basis and analysis for the conclusions of the commission, and then give states more time to consult with the different ministries so they will give their feedback on the project. So ultimately, of course, there's a whole debate as to how much states are engaging in the commission. I'm happy to come back to some of those questions. But in terms of the Use Cogens project, that's where we are now. So that then raises the question, what exactly are in the 23 draft conclusions and the annex, okay, or that were forwarded to states? If you look at the 23 draft conclusion, the commission has divided them into basically 4 chapters, 4 parts. The first bit, part 1, is really the introduction and about 3 main draft conclusions that cover the scope of the topic, which is a standard clause you will get in an ILC project, the definition of the object, in this case, use Cogens, and then there's this one that's described as the general nature of use Cogens. In these 3 conclusions, especially the definition, it wouldn't surprise you that the starting point for the commission was essentially Article 53 of the VCLT. So the definition really just takes the VCLT as a working basis, the VCLT definition that I read out earlier. But of course, by necessity, and this is really quite curious because the commission has received some pushback on this, the ILC tried to add a bit more value by introducing a bit more clarity. And there are those states that are commenting that, no, don't deviate at all from the text of the VCLT. And I'm happy to get into some of those points. But the basic takeaway I want to stress at this stage in terms of the substance is part 1 has its 3 draft conclusions, 1 on scope, 2, the definition of a peremptory norm of general international law, and very importantly, conclusion 3, which speaks to the nature of peremptory norms. And there, the commission basically adds a little bit of value by saying that use Cogens norm reflect, this is a hotly debated word in the commission, and protect fundamental values of the international community. They're hierarchically superior to the rules of international law and they're universally applicable. It's really, really fascinating, and it will be interesting to see what the Commission does when we come back this year based on the comments of states, but nothing too controversial, I would say, in part 1. Part 2 is comprised of 6 draft conclusions, and this concerned the identification as a category of use Cogens. And you have about draft conclusions 4 to 9, which address substantive issues. So the first, of course, is what exactly is the criteria for the identification of use Cogens? What are the sources of use Cogens? How do we flesh out the requirements we see in the definition, especially the elements of acceptance and recognition? The meaning of some key phrases that you see even in the VCLT text, the meaning of international community of states as a whole, and how do you show what is the evidence of that there's acceptance and recognition, and ultimately what is the place of this subsidiary means that we see in international law as a, Article 38(1)(d) in particular. What is the relationship between subsidiary sources in terms of identifying use Cogens? So if you think about judicial decisions and what have you. And here, I don't want to go on for too long, but I would just want to clarify and make, if you will, shine a spotlight on some substantive provisions in this category. Of course, the first one is identification, but then you have the criteria. The criteria is really, really important. And here the Commission basically says that for you to have a use Cogens norm, you have to establish that you fulfill a 2-part criteria. That 1, it is a norm of general international law, and 2, that norm is accepted and recognized by the international community of states as a whole, as a norm from which no derogation is permitted, and which can be modified only by a subsequent norm of general international law having the same character. So it's really not so much this provision, but everything else that follows in draft conclusions 6 to 9 that spell out in greater detail the substance of conclusion 4 that then adds, in my view, quite a bit of value. And I just want to be selective here, but I do want to highlight, for example, aspects of conclusion 5, which is headed curiously as basis for peremptory norms. And it's essentially the sources of peremptory norms, and it builds on Article 38(1) of the ICJ statute and kind of inverts the list. And perhaps that's something that we can discuss afterwards. But the basic idea is it speaks firstly to customary international law, and then it talks about treaties. Now, of course, in Article 38(1), you see treaties mentioned first, you get to customary international law, and then you get to GPL, the general principles of law. And the reason, of course, is that here the Commission is trying to identify the most common source in its own view of use Cogens norms. And by the nature of customary international law, which is comprised of these famous 2 elements, right, state practice and opinio juris, it would be the most common basis for use Cogens norms. So that's why in conclusion 5, the Commission stresses customary law first, and then it thinks of treaty provisions, and these are framed as a secondary source. And then, of course, general principles of law would follow afterwards. So essentially, it's like an inversion or reversal somehow, but really trying to look at the specificities of this particular project on use Cogens and the nature of use Cogens and reflect that in the criteria. So that's really just all I would highlight in conclusion 5. Conclusion 6 then delves into a little bit more detail of what acceptance and recognition means. And we had some really fascinating debates as to who must accept. Is it just states? Or can it be also international organizations and others? What is the relationship between other actors and their own acceptance of a norm of use Cogens and their recognition of a norm of use Cogens? And this is all discussed a little bit more in the commentary. But the point is that there must be acceptance and recognition, and it wouldn't surprise you to know that the Commission says it's really the acceptance and recognition by states. That's really what matters here. Kind of parallels the view that the Commission has expressed also in relation to customary international law. Then conclusion 7, this beast that's called the international community of states as a whole raised a lot of debate in the Commission. What is the international community of states as a whole? What is the threshold for that? Do you have a small number of states and they accept a norm? Or do you have a large number or a very large number? What is the threshold to show that this really reflects the international community as a whole? Do we have quantitative criteria, or do we have something more qualitative, or a combination of both? And how does acceptance and recognition fit in relation to other actors? So that's something that the Commission grappled with in conclusion 7. And then in 8 and so on, it talks about forms of evidence of this. So you're looking at, again, very similar to what you see in the customary law study, official publications, government legal opinions, diplomatic correspondence, legislative administration. I mean, it goes on, decision of national courts. All of this can be sources of evidence that states have accepted and recognized a norm. And then by the time you get to conclusion 9, is a throwaway subsidiary. It means like, yes, decisions of international courts and tribunals, in particular those of the ICJ, those are subsidiary means. And then it's like, oh, I could find the experts, the expert bodies, and the work of academics. That can also be an indication. You could look to those. So that's really all that's in that part of the project in part 2. In all that I have said, I don't think any section of the work of the Commission so far has excited more debate and more interest, and perhaps really the most added value, really, in terms of the Commission's project than part 3. Part 3 is about 12 draft conclusions. It's not because there are 12 in this part of the project. That's not the point. It's because this is where, more than any other area, where the Commission attempted to clarify what exactly are the legal consequences of a finding that something is of a jus cogens character. Now, I could tell you right up front that there are those who feel that the Commission hasn't gone far enough in clarifying the legal consequences of jus cogens. And there are those that have said the Commission has gone too far. Okay, but as always, and I think Don would back me up on this, in the Commission, when you have extreme views, the Commission always tries to find a way somewhere in the middle. And that's really where it is now. And this is giving you a little bit more added value, but it's really not gone crazy on you. Okay, in a sense, one might think of it, that's probably part of the role of an independent expert body on international law, which is not to push the envelope a little bit, but not push it too far, given that you want states to take up these norms and work with you in terms of advancement and adherence to those norms. So that's really where I would just highlight a few things, just for the purposes of giving you a sense of the substance here. And then, of course, before I would go back to the part 4, which is the final bit. And in this 12 draft conclusions, it's really fascinating because it starts out effectively with the codification of Article 53 and 64, that dealing with the treaty implications of having a jus cogens norm, right? And there you have the Commission basically restating Article 53 and 64, and then saying if you have a treaty that's conflicts with the norm of general international jus cogens norm, well, that treaty will be invalid. And if you have reservations, we had to grapple with that. There was not much about the relationship between reservations and peremptory norms. The Commission takes a position in relation to reservations. So if you cannot have a jus cogens norm that contradicts the treaty, clearly having a reservation to a treaty would not help you either. So effectively, it's kind of like almost a common sense point. And then conclusion 14 addresses circumstances that are relating to customary international law and what might happen if you have a conflict between a jus cogens norm and a customary international law norm. And in this aspect, I would just highlight 3 quick things. First of all, the Commission's position is that the rule of customary international law does not come into existence. It does not come into existence if it conflicts with a jus cogens norm. Okay, that's the first point. Second point, a rule of customary international law that is not of a peremptory character ceases to exist if and to the extent that it conflicts with a jus cogens norm. Really, really far-reaching. Third and final point, it's basically the question of persistent objectors. Again, if you're a persistent objector in terms of established customary international law, that will not help you in the jus cogens context. So that's really the takeaway, I would say, on conclusion 14. But it gets even more interesting as you go further into the project, because remember now we talked a little bit about treaties, and the Commission has now talked a little bit about customary international law, but it then goes on to talk about unilateral acts. So unilateral acts of states that conflict with the jus cogens norm. Again, doesn't help you. Jus cogens will be primary. You're not going to be able to get out of it, so to speak. Draft conclusion 16, and this is one of the most sensitive provisions, I would say, in the project, because this is where the Commission tried to grapple with this idea of obligations that are created by resolutions, decisions, or other acts of international organizations that may conflict with a peremptory norm. And essentially, the Commission's position is that if you have a resolution, a decision, or other act of an international organization that would otherwise have binding effect, it will not create obligations under international law if and to the extent it conflicts with a peremptory norm. Now, this particular provision has generated a lot of comments from states. I've been reading the state comments that just came in through from the Secretariat last week. And essentially, the majority of states have expressed support for conclusion 16. At the same time, and probably won't surprise you, quite a few states, especially those on the United Nations Security Council, have pushed back. So they are more or less, I would say, united against the provision, although they have different arguments. Essentially, the concern that they're expressing is that this particular conclusion may be going too far by implicating not just decisions of international organizations or resolutions, but including those of the Security Council that would have binding effects on states. And so the concern seems to be, in part, that if you open the door, the ILC opens the door for states to say, well, we're not complying with this decision of the Security Council because we do not consider that it's compliant with the use Cogens norm, you might find yourself in a situation where you undermine the authority of the Security Council and the bindingness of Security Council decisions, which we all know, especially obviously those taken under Chapter 7 of the UN Charter. And obviously also we have the paramountcy that the Charter provides for in Article 103. There are other concerns as well that have been expressed by the US, China, the UK around this provision, and of course the Russian Federation as well. They all center on, is this a good idea? There's a proposal to even delete the entirety of conclusion 16 or delete a reference to the Security Council. And I'll be very happy to hear views of colleagues in the room on that aspect, if this is of interest to you. I'm just going to leave it at that in terms of conclusion 16, but just note that it's a far-reaching provision, and note that even though the focus of the comments have really centered on response by the powerful states that happen to have a seat on the council, it does speak broadly, so it would be of application to regional bodies. Think about the European Union, think about the African Union, entities that have decision-making ability that's considered binding on the membership. Okay, from very mundane matters all the way to more substantive issues for those particular members of that organization. And so there's a little bit of need for caution there, and the commentary is very carefully negotiated, very carefully discussed in this area, even though, again, it will be interesting to now see what the Commission would do with the kind of feedback it has received. The takeaway is majority support for the provision, including these references. We had a big debate whether you should mention the Security Council expressly in the text. In the end, the general view was we shouldn't flag just the Security Council, but that the Security Council could be referred to as one of the examples in the commentary, which has been done, but that does not seem to go far enough for some states. So I'm going to move on to conclusion 17, which really deals with the use Cogens norms and their relationship to erga omnes obligations. And here I would say the Commission reaches the important conclusion that use Cogens are erga omnes in character, and all states have a legal interest in them. And quite importantly, any state is entitled to invoke the responsibility of another state for a breach of a use Cogens norm. Again, parts of this may not be surprising because it already came up in the 2000 draft articles on state responsibility from the Commission, but it does develop it a little bit further. And then conclusion 18 addresses the exception to the rule, especially the circumstances precluding wrongfulness under the law of state responsibility. And then, of course, in conclusion 19, there was this proposal to be very clear that there are particular consequences of serious breaches of use Cogens norms. And there the Commission speaks to this notion that states shall cooperate to bring through lawful means an end to a serious breach of a state of an obligation under that of a peremptory character. And it goes on to say that no state shall recognize as lawful a situation created by a serious breach of a use cogence norm, nor can a state render aid or assistance in maintaining that situation. Again, very much along the lines of the Commission's prior work in the law of state responsibility, so both in conclusion 19 and conclusion 18. And then conclusion 20 speaks to the interpretation and application of use cogence norm vis-a-vis other rules of international law. And here, the main point is that where it appears that there may be a conflict between a use cogence norm and another rule of international law, the latter, the rule of international law, should, as far as possible, be interpreted and applied so as to be consistent with the use cogence norm. So I've really kind of spent a lot more time on this part 3, going through individually the provisions. And the reason for that, as I said, was this is where the Commission has gone the furthest in clarifying the legal consequences of use cogence. Of course, without a doubt, this is the part that probably would generate a lot of debate also this year with the added dimension of the state input in the Commission's debate. But let me now move on to the last segment of the draft conclusions forwarded by the Commission to the General Assembly in 2019. And there you have in part 3, conclusion 21, which really tries to build on ideas contained in the VCLT, in particular Article 64, to set out some kind of procedures in terms of dispute settlement, especially in circumstances where there might be a claim by a state that I'm not complying or you are not complying with the peremptory norm of general international law. So it really centers on some kind of procedural device to have states engage with each other. And there's some even timelines that are specified in this section of the draft conclusions, really building on what has already been set out in the Vienna Convention on the Law of Treaties. In conclusion 22, there you have this very odd kind of without prejudice clause. There's a context to the without prejudice clause, and essentially it basically says that the whole project is without prejudice to consequences that specific use cogence norms may otherwise entail. And then it's really speaking to what was a proposal of the special rapporteur, essentially to deal with the question of immunity. Okay, what are the implications of immunity and in international law vis-a-vis use cogence? While I would say that there was broad support for the special rapporteur's proposal of a draft conclusion on that, the context is the Commission had been very divided in the separate topic on immunity of state officials from foreign criminal jurisdiction, where there's that famous draft Article 7 and the recorded vote. So members of the Commission did not want to get further into the debate about immunity and issues surrounding that controversy. Of course, that's specific to immunity rationem materiae. So the compromise essentially was that, look, we should just have a without prejudice clause that speaks to particular use consequences and leave it at that so that we do not reopen the debate on immunity. There is a second compromise part of the clause as well that I should note, which is there's this, and this connects to conclusion 23 actually, where the Commission now specified and has had this long debate as to whether to provide a list of use cogence norms. And there are different camps, as always with these issues, whether in the Commission or outside of the Commission, whether among states, whether amongst academics. And essentially the debate in a way goes way back to the beginning of the idea of use cogence, at least in the VCLT sense in the 60s, where the Commission engaged right away with the question, should we give a list? And the decision at the time was, no, we do not want to specify a list of use cogence norms. And then as the Commission went on in separate projects, it kept mentioning possible candidates. It did that even in the earliest phase where it talked about the prohibition of the use of force. But as it went through the state responsibility project, the fragmentation study, and so on, it would mention specific things like torture, self-determination, of course, genocide, and so on. The prohibition of crimes against humanity, aggression, racial discrimination. So the debate reopened in the Commission as to whether it would be a good idea for the Commission to give a list, whether that list would be illustrative or exhaustive, what is on it, how you determine what should be put on it, what evidence you would need, became very controversial. So in the end, the commission settled again on another compromise where it says that in the annex to this document, we will give you a non-exhaustive list of norms that the ILC itself, so essentially the commission quoting itself, has previously referred to as having the status of use cogens. And it said, you'll find that in the annex. And that was to make those members of the commission who did not want examples to be given a bit happier, because you bury in the annex what the list is, right? So that's really what the backdoor, the backstory behind it. And essentially then you get to the annex where the commission then lists items that it has itself referred to in the past. So again, prohibition of aggression, genocide, crimes against humanity. A little bit more controversial, the basic rules of international humanitarian law, the prohibition of racial discrimination and apartheid, slavery, torture, and the right of self-determination. So these are some of the elements that ended up, essentially 8 examples. But as always, and as you could pick up from the debate, what goes on the list, is it going to exclude other candidates for use cogens? What does it say about others that are out there that some might be claiming constitute norms of a use cogens character? The commission thought that this is the best compromise at this point, that in a sense we will leave it to the practice to figure out over time, maybe kind of like bringing us back to the position in the 60s. But the step forward is that in as much as the commission wasn't willing to give this kind of list in the past, including in the more recent state responsibility articles, now it's willing to have an example, a list of 8 examples of what is widely thought to reflect use cogens. One criticism that I found in the comments of states was that, well, the commission has given us this list, referred to itself, and really didn't use its own methodology that's set out in this project to identify these norms. So it would be adding more value for us if you actually did that. Like you use your own criteria for acceptance and recognition and all of that, and then you derive a list for us. So you get different reactions to that item. So that really brings me to the end of what I wanted to say in terms of just really a quick march through of this ILC draft article. I can tell you there are some members, and I'm going to be very transparent about this here, that thought that that list is a little bit dated. So for example, I was very cheeky, I think, especially in ILC terms, for suggesting that we could update ourselves from this list that more or less been hanging around from the 60s and think around, for example, gender discrimination. Couldn't that constitute a use cogens norm? And it's like, oh, guys, you are looking for trouble. We're not even going to respond to you, okay? So my claim about gender discrimination and some other new ideas as now reflecting the different sensibility of today didn't go too far. Okay, and of course, in fairness to the commission and my colleagues, the idea was we're not going to start assessing norms now. We'll just look at things we referred to in the past. These were not in the list, but then some of us are saying, well, maybe that's not good enough. Okay, I'll leave it at that. I look forward to your engagement, your questions, your comments, your critiques, and of course, any ideas or anything to improve. I can tell you in terms of the final question, which I had asked, remember my final question was going to be in the last 3 of the questions I asked, what would be the likely next steps? At this point, we have the report of the rapporteur. He's gone through the comments of states. He suggested very few changes, okay? So you have about 23 draft conclusions. I counted only about 5 conclusions where he proposed really, really minor changes, especially conclusion 5, 6, and 7, which really center on essentially titles of the draft conclusions based on titles proposed by states. But in terms of the substance, the biggest change or proposed set of changes, because these are proposals of the special rapporteur, not of the commission yet, the commission would debate them and make a decision, really center on that procedural clause on conclusion 22, which speaks to procedural requirements where you have a claim of a violation of use cogens or invalidity. Okay, so that's really where the lot of the proposal of the rapporteur came. We will see in the ILC, the first week, we're going to open with this topic. We're going to debate in the plenary. And as usual, I think the items will be referred to drafting committee, and there the process of negotiation would begin. Ultimately, what would happen is the commission will settle on a position by the end of the first half of the session. The rapporteur would have the middle period, that 1-month break we have in the middle of the summer, to finalize the commentary. And then the commission would come back and look at all the text on this topic and the other second reading topic, along with the other topics, and then adopt those texts. And in the context of use cogens particularly, it would then make a recommendation to the General Assembly. You can foreshadow that by looking at the rapporteur's report. And in part 6, he basically proposes that the Commission recommend to the General Assembly that they take note of the draft conclusions of the ILC, that they commend the draft conclusions together with the commentaries to the attention of states and all those who may be called upon to identify peremptory norms and to apply their consequences. This is very similar to the recommendation that the Commission made on the identification of customary international law study. In the fall of 2022, during the International Law Week debate of the Commission's report, it's likely based on the practice in the past. Nothing is ever off the table, obviously, for the GA. They could do whatever they want. The Commission's work will be complete, but then the GA will make a decision in a formal resolution specifically on this topic itself, and it would be to whether to take note. Now, you might think about the legal value of taking note of something, because in GA speak, that means neutral, but that's been the more recent practice. It is different from endorsing, for example, but they end up being things that go out there in the ether that are then used by jurists, legal advisors of states, judges at the national level, international level. And it's fascinating, that process of items coming out of the ILC without having any formal status having such a big impact. And I was just struck just a few days ago reading the ICJ's recent judgment in reparations concerning Uganda and DRC, and they're referring to the ILC articles on state responsibility, which it's in one section only, they said, which by the way are customary law. And after that, they never referred to it, right? The item is before the GA, formally. The GA is still going to debate what to do with the draft articles. ICJ is using them, applying them, and it's quoting commentaries. That's the nature of the beast, okay? Now, some people are uncomfortable with that, but the reality, I think, of the process of development of international law does say that when items come out of the ILC, they do get taken seriously at different levels, of course, and that ultimately they do help to frame the terms of the debate in a given area. It will be very interesting to see going forward what would happen with the outcome on the Use Cogens project. Thank you very much for your kind attention, and looking forward to the conversation.
Thank you. Thank you very much, Charles, for taking us through the process, how the Commission sees it of the issue and how the issue was dealt with, and also the current status. We still have around 20 minutes for interactions, questions and answers. So before I open the floor for the audience, I have one comment. In the draft conclusions, I noticed that sometimes we refer to the community, the international community of states, as it appears in the Article 53 of the Vienna Convention, and in the other conclusions referred to the international community as such. Is there any difference, or is it? I don't know. How do you explain that? For instance, draft conclusion 3 and a draft conclusion 17.
Okay. So, Pacific, did you want me to address each question, or should I take a round? It's up to you. Whatever you're.
Let me take a round of questions.
It's up to you. Whatever you know.
I see Penelope, and then Joseph, and then John. Penelope, go first.
Thank you very much, Pacifique, and thank you very much, Charles, for a very interesting talk, and for all your work on the ILC as well. And I had a question. I'm glad you talked a little bit about the list, because that is, I think it is concerning that there's no kind of development in that list, because, for domestic courts that are trying to determine what rules are customary or use Cogens norms, they're going to look at this list. And so, like, I'm surprised, for example, that the prohibition against forced labor isn't on there, and you noted gender discrimination. So I wondered if, I think you spoke a little bit about what the rationale of the Commission was, but maybe you could say a little bit more about yourself and what others had said about it. I looked at the list of people who are on the Commission. It doesn't even look like there are very many women, although I could be wrong because you can't always tell from the names. But maybe you could just say a little bit about that if you, it's a very vague question, but thank you.
Joseph?
Hi, Charles. Good seeing you again. Thanks for the very good presentation. Like Penelope, I also have an issue with the list or a question about the list. Exactly as you alluded to, that countries or states have asked why the Commission doesn't apply its own Rule 4 and identify particular rules. It's not only the only time, or the first time that the Commission goes in great deal of detail expressing norms. I mean, the Cogens Humanity Project is a very good example. So, could you maybe explain, as Penelope says, what is the thinking of ILC members in not having their own project in using conclusion 4 and establish the list? I mean, they give methodology. You would think that at the minimum, the Commission itself would have a project, even a separate project, to identify more norms or more contemporary norms. Thanks.
And finally, John.
Thanks. Thank you, Charles. Very interesting presentation. My question is related to conclusion 16, the one that creates this potential problem with the Security Council's supremacy, or the supremacy of its decisions and their binding effect. I mean, it raises very, very interesting and troubling questions of hierarchy of norms. Of course, you may have more than one kind of super norm, it would appear, and then the question is which is going to trump which. So that's interesting in general. I do wonder, was any consideration or discussion held in the Commission about the decisions or the binding effect of decisions of the ICJ for the parties to contentious proceedings? It seems to me that those are decisions, and I'm not sure whether or not the ILC would have considered the ICJ an international organization. I can't see why not. Because then it raises a whole other can of issues in terms of the binding effect of judgments if one party considers itself to be wronged in the outcome. So, I mean, it was very, very problematic issues, I think. And so I'm wondering whether they turned their minds to that or whether that was not considered. It's not clear in the commentaries. Thanks.
Good, thank you,
Charles.
Okay, thank you so much for the great questions. We'll start with you, Pacific. So I think you asked about why do we have in the draft conclusions in some sections referring to the international community of states and then international community, right? So in some other conclusions say international community. And there's an effort in the Commission to be mindful of one of the points that I had made earlier, which was the Commission recognizes that it is the practice and it is the views of states that will be very material if you think about in terms of the sources of use Cogens norms. But the Commission was also alive to the fact that there are other actors now in the international arena, including those created by states, if you think about international organizations, that have had quite a prominent role in developing norms of international law, including norms that may have a claim to a use Cogens character. So the Commission basically didn't want to necessarily foreclose that other actors and their own views of what are the norms that are now out there that will potentially be use Cogens will be coming from the practice of entities other than states. So the effort was to cabin in specific contexts international community of states, and then we grapple with what does that mean qualitatively and quantitatively. Do you need to have a representative group of states? If we think of a very large majority of states, do you want a smattering of states that are really representative of the world? And some of the questions in the comments from the states I thought were very interesting. Some countries were asking about what about legal systems? What about languages? If you think about Spanish, if you think about French, you think about Arabic and so on. So it's a very, very interesting question that the Commission has to grapple with, because we really just dealt with the question of very large majority, and we said it has to be representative. So it's both qualitative and quantitative, but some states are not happy with that. You know, like the United States thought that the threshold should be higher. And there's a reference even in one of the comments to the Nicaragua case. So the United States submitted that, well, if in the Nicaragua case, the ICJ said that for a rule of customary law to emerge, you need to have virtually consistent and uniform practice. Surely a use cogens norm, if that's the finding for the threshold for customary international law, surely for use cogens norm, it's even more important that you stay very close to that high virtual uniformity. So it's not enough to say very large majority, because that's ambiguous to us. So I think it's a good point, Pacific, in terms of your question, but the effort was to really distinguish between international community, which is inclusive, but not necessarily just equivalent or coextensive with states, and international community of states, precisely just them. You have other actors out there in the international arena. So that's all I would say on that. And to Penelope and Joseph, we're both concerned about the list. So Penelope, I think it's a great question in terms of there've been a lot of developments in terms of the list. And definitely, even if you look at the claim by the commission that there's a lot of practice when it comes to use cogens, if you look at the syllabus that was adopted by the commission, they point to a lot of judicial decisions, right? And we know some courts are clearly, a little bit maybe progressive than others. And there's a lot of findings that some things are use cogens. If you think about inter-American system, for example, right? Like I would say there, if you think about human rights, perhaps pushing the envelope a little bit, you'll find a lot of findings that may not be necessarily supported by others. So it does raise the question of, is the list that we're using now, by making the choice that that list is something that just reflects what the commission has referred to in the past, has it, and this ties to Joseph's question too, has the commission then really had an opportunity to apply its methodology? The concern was it would take a long time in terms of a study to apply the methodology of the commission to be able to assess the landscape out there and identify all these use cogens norms. So the compromise was, well, we don't have the time to do that right now, but we have things that we've referred to that have not necessarily generated a lot of pushback from states. So why don't we go with those, right? Because they've been mentioned and they have fundamental, prohibition of use of force. Nobody's going to argue with that. Then some members questioned the content of those. There are actually members who not just questioned, what does it mean to say basic principles of international humanitarian law? What does it mean to say that? I mean, are you talking about grave breaches? Or do you go beyond grave breaches, right? Like, what are basic principles? And then you get into a debate that shows some of the challenge for the commission in terms of identifying those norms. So effectively, it became a compromise of just, well, we don't have the time to study all of this. If we start going down that path, it could be methodologically very difficult. And we don't want to, at the same time, foreclose developments. And I think, Penelope, you pointed to other examples, potentially like forced labor. There are a whole host of other potential candidates. If you were going to do a study, even just looking at judicial decisions and national and state practice at the national level, and then of course, if you look at the international level in terms of what states are saying in international bodies, speeches by government delegates, diplomatic correspondence, all the sources that the commission says this is what you look at, you could see that is very, very challenging. So the choice was really just to say, look, we've referred to this in the past. And they seem to be okay, so let's just put them down there. But it does leave me personally uncomfortable that we didn't apply the criteria, and you see that criticism. And I think that ties very much, Joseph, to the question that you were asking. And it was felt that maybe at a later stage, that kind of engagement can happen from the commission. But in this project, really, I think the added value is really clarifying some of the consequences and then putting that list out there. That's really sort of like the big development. And then I think that brings me to John. I know that may not be satisfactory really as an answer, but to John, your questions about the binding decision, the implications of use cogens vis-a-vis the binding decisions of international organizations, including potentially the International Court of Justice, is fascinating because we kind of, and you point this out, I think correctly, we had a big dust up, to be honest, on the floor of the commission about the reference to binding decisions of the Security Council. We didn't go too much beyond that in terms of going into, for example, ICJ jurisprudence and what would be the effect of these elements that you are talking about, which is if you have a contested case and the court makes a finding in that case. Now, obviously, there's always that response that, as you know, in Article 38, even the caveat, especially when you get to 38(1)(d), one of my new, for loves now, subsidiary means, is even the decisions of the court are not binding on the court, binding on the parties only in respect of that particular case, right? Like you're stuck there. But of course, we know the reality is more complex, that the court actually would look at these decisions. And so when it says something, it matters a lot. Like if you think about what it's saying now in the reparations to judgment case. So perhaps that's one of those points, John, that I would want to engage you further on. And I would want to perhaps raise myself as part of my own response now, right? Because as the members of the commission are studying this report, I will be speaking in the plenary debate on these issues and saying I will really address all of these questions. So it'll be very interesting to hear more of your own views on that as well.
Thank you, Charles. I think there is a follow-up question from Penelope, and then if we get a chance, there is another question through the chat.
Oh, thanks, Pacifique. So I guess I just wanted to follow up, Charles. Is this list then a done deal? Because to me, it's damaging. Like, why we could just go back and look at the rules on state responsibility and say, oh, well, we need to develop more. But to have a new list now, I think that states will look at that as that's it. And there's no room for others at this point. I think that, well, that would be my view anyway. So I guess, but you're saying it's a done deal.
You know, it's hard to say with the commission because things can change. But what I can say is it's very difficult for the commission when you have compromise positions, which is what this list represents. The list is a compromise on a number of levels. The first level is you do have the proponents of having a list and not having a list, right? You have those in the commission and you have them among states as well. So there are states that said, it's not a good idea to have a list. Don't give us a list. We don't want a list from you. There are those states that say, that's great. That's one of the added values of this particular project, because for the longest time, we don't have a list, right? We have these candidates that everybody talks about, at least these prominent ones from the commission, so give us a list. So the effort was at that level to say, okay, well, we're having a list. So that camp has carried the day. But then it gets to the second question, which is the difficulty that you are posing, which is, well, what is the content of the list? Are you really actually, and this is Joseph's point too, are you really applying your methodology to give us the list? Because surely if it's a methodology study, as you are saying it is, to identify, well, why don't you apply your own methodology and give us the list, right? And in that process, I think there are those who are very concerned by having the list, even if you say it's illustrative only, you're now precluding the potential development of other candidates that may be at the edge, for example. Like, what about norms that are not as widely recognized, but they're kind of getting there? Would the ILC by implication be dampening the development of that particular norm because somebody would, as you say, well, you see, the ILC gave us that list, so you're not on that list, so sorry, next time. So that's and I don't know that the answer was satisfactory, but I think what we have now seems to be where we will end. That list will not be reopened. At best, I think you will see a little bit of a buffing to the commentary in terms of this list. But even that, there was no appetite to mention proposals by ILC members like myself and so on. There was no, and I have to say I didn't, because I didn't get a lot of support, I didn't even push my own, because once it's going to be a waste of the commission's time if you are like in a strong minority position. You could procedurally at the first reading stage insert language to kind of send a flare to states and hope you generate a reaction. But oftentimes they don't take you any further really. So you end up just sort of like holding your own peace and letting, sort of the process work. Yeah, I hope, again, like I said, it's not satisfactory at all, but that's what we have now. And I'm suspecting that's what we'll end up with, that list as is. Yeah.
Thank you very much.
Okay, there is a question from Jaber who is saying that he doesn't see any progress in the draft conclusion on the use Cogens unless more clarification of the VCLT provision. Would we elaborate on this point?
Yeah, thank you very much to Jaber. And it's definitely true, the predicate point about Yakuba Sise. Of course, that's by my bad in not mentioning. There's another ROU connection right there. I think one of your own graduates, actually, right? Ivorian member. Of the commission, Yakuba, so one of my good colleagues.
He's a professor too here, yes.
Absolutely, of course, yes, of course, and a good friend in the commission as well, that I work with very, very, very closely, especially among African members. So yes, just acknowledge that. But then on top of that, getting now to the substance in terms of this question about whether the Commission really has added. I think this probably would be a matter that we'll leave for academia and others outside and the states to comment on. The claim that the Commission would make is the claim that I was making earlier, which is that the Commission took as a starting point the VCLT. It was very, very mindful of the importance of the VCLT, even though if you think about the number of states that have actually subscribed to the VCLT in relative terms, it's not as universal as it could be, but it definitely has set the standard, including for states that are not parties to the VCLT. Much of it is considered a customary international law. Having said that, the fleshing out of the legal consequences in Part 3 of use Cogens is where the Commission has elaborated a little bit more, both to the treaty context, but also customary international law, and then other things. So that's really, I would say, where the added value is. Whether it's gone far enough is a question that I think would be a matter of appreciation. And there are states that have said it hasn't gone far enough. And there will be the states that said it's gone too far. So again, it brings me back to that point about finding a middle ground, which is often what ends up happening in the Commission.
Thank you very much. Thank you. Thank you
you.
for me and for my students too.
Thank you. Great question, of course.
Yes, I think we can take 2 more minutes for you to address a follow-up question from John Curry. Again, it's on the chart and it's on the list. So the list is problematic. So have you read it, or you want me to read it?
Yeah, I see it now. Let me just have a look at it.
Okay.
Yeah, well, so I think, John, I mean, it's Joseph, it's Penelope, and probably others who have not spoken, right? In terms of the concern about the list from the Commission. It definitely does try as a procedural matter, especially when you're dealing with questions that are kind of similar, especially when you think about, the recently completed customary international law study. So we really try to draw on that aspect. And if you think of the conclusion that I was highlighting, where the Commission really started there, right? If you think about the sources of international law, it didn't actually say treaties, which is what 31D does, right? 31, sorry, it does in A, and then before it goes to customary law, and even the Commission's own project started with treaties. Here we said customary law because of the nature of customary law. State practice opinio juris, so we look at that as a primary means of identifying. Now, how does that feed into the list? I guess there are those who've even pushed back on the Commission's study on customary international law, as you know. People who are skeptical about the two-element approach and how far the Commission has gone, especially in terms of explaining some of those requirements. But at the end of the day, it is drawing on that base as a source to say, okay, this is what we will look at. But then, of course, in terms of the list, it hasn't applied the criteria, right? That's a problem that people are having with it. It has not applied the criteria. So we don't even see the Commission looking for the state practice and the opinion juris, whereas it, it's mentioned it along the way. Even in the Law of Treaties project, it talked about the prohibition of the use of force, and it cites, of course, the relevant references. But in terms of this kind of study, there could have been more added value, perhaps, by delving into that detail and then looking for the state practice, then looking for the opinion juris, and maybe identifying the candidates that are there, that are close, and then leaving the ones that it does not consider to have sufficient basis in customary international law. But yes, it does draw heavily on the customary international law study. And I think it's explained by the sense that this is the primary source of identification of a peremptory norm.
Great, thank you very much. In any case, John said it was a comment. Yes. There was a comment on a comment, which is good too. Again, on behalf of the international group, let me thank you, Charles, again for giving us time to share your reflections on this important issue. Of course, we'll be happy to have a follow-up discussion once the GA, the work will be finalized. This time it will be in person, not online, and we make all the arrangements to have you here during winter times, from Florida during winter times. Okay, again, thank you very much, everybody. I think there is one Tony, do we have one more talk left? You are not.
Yes, we're hoping to have one more talk, although we haven't got confirmation finally on the speaker.
Okay, so they will be hearing from us.
Yeah.
Yeah. Thank you very much. Bon après-midi tout le monde.
Thank you very much for having me, and it's a great conversation. Looking forward to the opportunity to come back.
Yes.
And you're always welcome in Florida too.
Okay.
All right.
Thanks so
Thank
much.
you.
Thank you. Okay, bye-bye.
Okay, bye-bye.